All right, good morning, everybody. Welcome to a live oral argument session of the 5th District Court of Appeal. My name is Dan Traver. I'll be presiding this morning. I'm joined by my colleagues Rand Wallace and Mary Nardella. Happy to see you all here in person. We've got two cases on the docket this morning. The first is going to be Stephen Craig Butler and Carol Marie Butler versus Clark F. Brown Jr. and Shauna Karen Brown. It's case number 21-1494. We will then call the second case immediately thereafter. Ms. Harris, you are representing the appellant. How much time would you like for rebuttal?
5 minutes, please.
5 minutes sounds great. I don't have to change anything at that point. Floor is yours.
Good morning. My name is Elizabeth Harris, and I do represent the Butlers. We're here this morning on a private nuisance that arose from conflict between neighbors regarding the Butlers' use of their dock lights. We have raised two issues, and I'm just going to start with our very first issue in our brief, which is with respect to the injunction. Here, the Browns sought an injunction, and specifically that injunction sought to enjoin the Butlers from using their lights. Now, in the final judgment, the judge ran that injunction with the land, and we've alleged that there is a due process violation because the action was not an in rem action. It was an action to enjoin specific conduct by the Butlers on that property. And so in entering that injunction, running with the land, the courts violated the Butlers' due process rights.
Counsel, when you argued that the court violated the due process rights of your clients, are you making an argument in your initial brief that it was fundamental error to enter the order that they did?
Yes. Our position would be that any time a court grants relief that is not specifically requested, the court has exceeded its jurisdiction, the authority that's been invoked by the pleading, and so there would be a fundamental or a violation of their due process rights for lack of notice. And I believe that's exactly what's happened here, because contrary to what's asserted in the answer brief, if you look at the paragraph that they specifically cite, and I believe it's paragraph 36 of the complaint says, Browns seek for this court to enter an injunction against the Butlers, preventing Butlers from operating the dock lights at all, or in the alternative during the entire sunset to sunrise time period. And contrary to what they later assert in that very paragraph of their answer brief, where they maintain that the land use is what's being restricted, I would suggest to you that that's not what's happened here. They have specifically complained and asked that they turn their lights off. And that's what the court did. And in addition, the idea that this would run with the land and forevermore prohibit non-parties to this injunction, I would suggest is a violation of due process.
Counsel, had it been properly framed by the pleadings, could the Browns, as a matter of law, obtained the type of relief that the trial court granted?
I think what you're asking is if it had actually, in fact, been directed at the property, and I would believe that even the style of the case would have to look different in order for it to be an in rem. If we were to do some type of comparison to maybe forfeiture actions that are actually against the property.
Is your argument that it should have been styled in re?
Well, it's not just a style, I would suggest, because even if it had been styled in that fashion, but they were not seeking a restriction of the land use itself, their actions or their complaint is directed specifically at the Browns using the lights on the dock. It's not, for example, and I don't know that I can come up with a quick example, but in the sense that the dock is somehow the dock is being used improperly, or the land. You know, it's not.
Well, it seems like it'd be one of those cases where, like, there were drainage, a consistent, condition going from one property to the other, where you would need to stop the drainage as an ongoing basis, as opposed to something where literally the lights could just get turned off.
Precisely, or maybe where we were talking about fill, where the land is being used and fill is being taken from the land. That's not what we have here. We have, you might compare it to some of the other cases that where a pool pump. The pool pump, you turn it off because it's making noise. It's not that the land is being used So I would say this is comparable to that. In the running with the land, the Butlers, when they sell this property, an unnamed party to this action is now going to be subject to the injunction as well. So our position would be that the court did exceed the jurisdiction invoked by the pleadings and therefore violated the Butler's due process rights.
Here, you keep referring to turning the lights off, but I believe wasn't the result of the injunction they were given the option to convert to a different type of lighting for the dock? Is that correct?
I don't, I don't know that I can answer your question directly because I'm drawing a blank, whether it actually says that. But they were told to turn the lights off with respect, I believe it's the eastern side of the dock. And so whether they were given the option to, I'm sorry, I'll have to look because I'm drawing a blank on the answer to that question and I apologize for that.
Is there anything else that the Browns would have needed to show to obtain NREM relief? I know you were giving some examples with Judge Traver, but is there anything else that comes to mind that needed to occur if NREM relief or quasi-NREM relief was going to be granted by the trial court in this case?
Well, in addition to having specific pleadings that give the court the authority or the power to do that, which we don't have here, I think that they would have to demonstrate that the property is being used in a fashion that met the injunction criteria, that there's irreparable harm, that there's no adequate remedy of law by the use of the land. And again, kind of going back to the example that we talked about, where you're moving fill, for example, they would have to demonstrate that those actions amount to an injunction that cannot be remedied at any point and cause that irreparable harm to occur. So not only did they have to plead it with respect to the land itself.
When we talk about the power of the court, you use the word jurisdiction in your brief. Can you tell this court what type of jurisdiction you're alleging the court lacked?
Well, I think in this specific circumstance, I do believe it is subject matter jurisdiction as opposed to a procedural or case jurisdiction. Because, I had a law professor, he would talk about jurisdiction being a train ticket, and you needed to have the right ticket to get on the right train. And it's just something that all these years later still makes sense to me. That pleading gave the parties a ticket to get on the specific train. And that pleading was just solely one that was for a not an in-rem action. This court didn't have the authority by the virtue of that ticket, that pleading, to issue something outside of what was requested. So I do believe it's subject matter jurisdiction, that when you plead something, that kind of triggers what the court is permitted to do, as opposed to a procedural where maybe the court, this court just recently issued an opinion about the UCCJEA, where you need to consult with the foreign court, where it's more procedural in that sense. I think here we've got something entirely different that is centered strictly on the authority of the court to act in the fashion that it did.
If we don't see this as a subject matter jurisdiction issue, and we see it instead as possibly a procedural jurisdiction issue, and you rely on your due process argument, are all violations of due process fundamental error as a category? So
I think that what we have, when you fail to give a party notice to what their actions may be prohibited or what the court may be doing with respect to your in your case, here we have to go from the premise that we have to notice individuals what the court is seeking to do and how your actions may be impacted, and in particular here your property, right? Because this went from we want to enjoin you from turning your lights on to we're actually going to restrict your property forever, in perpetuity, because that's what the running with the land would do, contrary to the idea that it's a permanent injunction that's asserted in the brief. But I believe when you don't give notice to what the court can do and what actions you may be prohibited from doing, that is a due process violation and I think what you might be asking is whether we would need to object or file a motion for rehearing or things like that. I think these do ride to that fundamental basis of a due process that would require reversal in the absence of adequate notice to the court's ability to restrain you in some fashion.
In a classic in rem proceeding, you're typically obligated to serve notice on anybody who has any right, title, or interest in the property. You see this with unknown tenants, for example, in foreclosure cases. What effect, if any, should we give that as it relates to your first argument?
Well, I think it bolsters the position that this wasn't an in-rem proceeding, because none of that has happened here. So again, how were the Butlers on notice that this was a restriction of their land use?
Well, I mean, I'm talking about somebody theoretically other than the Butlers. I mean, you could have somebody who had a right, title, or interest in the land who now has a covenant running against them, and they never had the opportunity to object or say anything about it.
And I think what you're asking me is does that, the failure to give that notice alleviate the obligation to do that notice? Am I following your question?
I don't think I think I'm asking you what could be classified as a softball question. Isn't that another reason why we would see some due process issues with what the trial court did?
Absolutely. Absolutely. I think that goes to the basis that there is an insufficient notice here with respect to the property. And they're distinct. And even what they've asked for, they're talking about enjoying the use of the lights. It's not even enjoying the use of the dock. They're saying the lights in and of themselves. So I think that's important. I'd like to move to our second issue, and because I think one of the what we have here is a view, and I think that goes directly to the point that we raised with respect to the erroneous findings. We have a view here, and the purpose of a view is to explain or clarify the evidence. It's not intended as a fact-finding venture. It's not intended for the trial court to go and make findings of fact that then serve the basis of the judgment. And I'd suggest to you that's exactly what happened here.
Was there an obligation to object there?
I would say when the view is occurring, I think the parties are entitled to be of the position that the view is going to be properly conducted. And when the final judgment is entered, and in this case, I think we can point to findings that are made directly in contrast to the position that's asserted by the Butlers, the time for objection is passed. And I think that's why we have the problem with a view when a judge crosses that line between
Those
making...
factual findings, though, that appear for the first time on the face of the judgment. I mean, that seems like a candidate for rehearing, Judge. You probably shouldn't have done it that way.
I think that the idea that clearly erroneous findings, I'm not familiar with case law that requires a motion for a hearing as to clearly erroneous findings. I don't believe that's what the rehearing rule requires when you have a non-jury trial and there are clearly erroneous findings or an assertion that they're clearly erroneous findings. So I would be of the position that what the trial judge did here was, and I didn't write the paragraph down, but I did quote it, in the final judgment, I believe it's roughly around page 3 or so, the final judgment says the lights were installed under the edge of the dock so that the lights shine out rather than down. As installed, the lights do not shine on the walkway of the dock. At the view, the court had to use a handheld flashlight to be able to see the dock surface to be able to walk on it. Then a couple paragraphs later, referencing the above finding, the trial court found that the lights do not provide security from trespassers. And the reason I think that is so important is because the nuisance only becomes a nuisance if there's no reasonable use. And the Butlers provided, up until this finding by the judge that he independently makes based on his observations, that they'd had trespassers, that they needed to secure the dock, that they'd had people on their dock come both off the river and off the land. And so we have the trial judge making a finding that directly goes to the defense, that there is a reasonable use for this land.
The exhibits that were attached as part of the file as well, are those contrary to the findings of the judge, or are those consistent with and cumulative to the findings of the judge? And I'm not arguing with you about as far as the view. I believe if this were a jury trial, wouldn't there be standard jury instruction? I would imagine that would impress upon the jury that what you're getting ready to participate in is not evidence, but is merely provided so that you can maybe gain a context based upon all the evidence that you're receiving in the trial and how that applies. But in this case, you not only have obviously what the judge referenced in what the judge saw, but there are the exhibits that are entered into evidence that may be consistent with the findings. Do you understand?
I think I do understand your question, and I don't believe that based from the exhibits that you could reach the conclusion that's in direct conflict with Mr. Butler's testimony. Mr. Butler says, we've had people on our dock, we've had people on our boat, and the walkway is lit as you walk on it. The judge says no, which is a little bit of an interesting finding. I'll just make this kind of a side comment. If the lights are so bright, yet the judge needs a flashlight. So I would suggest that those two things are in conflict.
But I think wasn't the point behind that is the lights are bright, but the lights are more illuminating down underneath the dock, and they're not providing guidance, or they're not lighting the top of the dock, which would be the walking surface where people would use to walk out to the end of the dock. Is that accurate? Was that depicted in the photographs?
I think that the photographs, to a large extent, reflect what you've said. However, we do have uncontradicted evidence that Mr. Butler says the lights illuminate the pathway. The judge makes a finding of his own completely contrary to that. And I would suggest that the Browns would have had to come in and say, well, that walkway is not lit, and however they would bring that evidence forward, that it wasn't for the judge to say, it doesn't provide security for trespassers, because there's a leap, in my opinion, from anything you can take from the still photographs to the leap that it doesn't provide security for trespassers. And that's a finding. There's no testimony of that at trial. That comes solely from the view.
What was the evidence of trespassers that was entered before the court? Was there a history of criminal complaints of people trespassing on the property or people receiving trespass warnings? I failed to see in the record specifically how that was borne out.
Well, Mr. Butler testifies that they had found individuals, that at least on one occasion he had chased people away, that they had found people coming off the river onto their dock, that gentlemen had entered from the property to go fishing on the dock. He had testified that he has an alarm, and the alarm has sounded, I believe it was 3 times. So there is evidence that there have been trespassers on their property. He has a sign that says no trespassing, there's a guard dog. So he's taken measures, and he testified to the fact that there have been individuals on his property who were uninvited. Both Mr. and Mrs. Butler testify to trespassers entering their property. So in light of that, for the judge to make that leap, that it doesn't provide security for trespassers in the absence of evidence from the Browns in any fashion, I think that makes this view and this finding very problematic.
You are decently into your rebuttal time.
Okay.
Do you want to reserve the rest?
Yes, please, sir. Thank you.
May it please the court. My name is Jim Ippoliti, and I'm here with my associate Nathan Maloon, who handled the case on the trial level. Appreciate your time today. It comes down to these two issues, I think, that we just spoke of, whether we've got a due process violation and whether the judge was justified in his factual findings. I think I can dispose of the factual finding ones relatively quickly. The parties, there was no objection to this view. In fact, prior to the view, there was a list submitted of the places that they would go and visit. And that was filed with the court on May the 4th at 4:35 p.m. prior to the visit. So the parties knew where they were going, what they did. So the judge went in, and he is looking to see, the honesty and the veracity of the witnesses that he heard of. He wants to see for himself whether those lights really shine into the house. He wants to see whether those lights are really needed for security, because that was the testimony. The testimony of Mr. Butler was, we need these lights to shine on the dock for safety and security. Well, he went there himself and needed a flashlight even to see the dock surface. So to me, his inclusion of the reference of having to use a flashlight is more to respectfully say, you weren't telling the truth, Mr. Butler. Those lights are not needed for security. I looked for myself, and it was dark. And likewise, I went to the house of the Browns. It's on the list that was filed. And I saw, yeah, those lights are bright, excuse me, and they do shine into the Browns' house. The testimony from the Browns was that they shine into the house. The veracity and honesty of the Browns was shown to be true, and I think that's why that was included. But again, there was no objection. It was not properly objected to during the trial.
But what would be the objection to the view prior to the view? What would be a logical objection?
Okay, could be a number of objections. The first is a general objection that there's no reason for this to occur. The testimony has been brought forth by witnesses, by photographs, by a couple of experts, and that if it's not before the court through that means, that then it shouldn't be a fact-finding mission from the court. So they could have objected simply just on that basis.
So that would be a relevant objection.
Yes, sir.
Okay.
And then
What would be the
secondly, secondly, they could have also just objected to say, I want a court reporter here. I want an officer here. The court actually asked that, and it's referenced within the brief. But neither of the parties said, yes, that's necessary. They went out and they looked. They wanted to look and see what it is that they're saying, whether that's actually factually
No
true.
testimony is taken at the view. Nothing is said at the view, which is standard, I believe, for jury views. What's the necessity of a court reporter?
Necessity of a court reporter just to document that nothing was said. But I absolutely agree that nothing could be said. I think it would be more to document that nothing was said. Not that there would be continuation of conversations that would therefore be part of the record. It would be more that, look, the record is clear that there was nothing discussed relative to the case. It was just a visual viewing.
On the first issue, do you agree with me that first off, do you agree that at least on the face of the complaint, relief was just specifically sought against the defendants below, as opposed to relief running with the land?
I think if you look at the complaint itself, yes, but in the same aspect, you don't check your logic at the door when you walk into the courthouse. You've got to look, the court sits in equity, and they're looking at this and saying, how can I resolve this issue based upon the law? They sit in equity, they can carve out a resolution that resolves the points that are before the court.
You make an assertion in your answer brief that every injunction, and I'm going to paraphrase you, so forgive me, Mr. Ippoliti,
Yes,
if I don't get it exactly right. But you make an assertion in the answer brief that effectively any injunction runs with the land. There's no authority that's cited for that. I couldn't find any. Where are you getting that concept from?
I'm using it from a logic standpoint, not from a legal standpoint, Your Honor. What I'm saying that there's no law that says it doesn't run with the land. And I agree with you that there's no law that says it does run with the land. It's a logic argument. And the reason I made it, Your Honor, is for this very purpose, is we've got obviously highly contentious neighbors here. Clearly have got, they are more in love with their lights than they are with their money, because this is an expensive case both on the trial level and on the appellate level. And there would be nothing to stop this issue from coming directly back to the court, because they could open up Butler 1 Inc., transfer by quitclaim deed to the property, and we're right back before the court.
Wouldn't Butler 1 Inc. just be an agent of the Butlers?
But again, it would take a court to make that decision. It wouldn't be, it would be back in court. This would be a continuous effort. It would be Butler 2, Butler 3. It would just be continuous. And the court, I believe, saw that, and I think that's why they included the specific language that it runs with the land. So when...
Is notice absent from your logic versus legal argument?
Is notice absent?
Notice to the party. I mean, you're totally disregarding due process and notice to the party, I believe, by making your argument that this is based upon logic and not legal.
Understood. The parties had proper notice that the issue was a permanent injunction. We want to get rid of these lights. I don't care if it's who the owner is. These lights shine into our house and are a nuisance to us. I think there was proper notice on that issue.
Wouldn't the Butlers, though, be then on notice that they might want to put on different evidence in front of the court? You know, for example, here's how my property is diminished in value on a going forward basis, say if I ever want to sell it.
Butlers were certainly entitled to defend their cases in any way that they chose, but they did not choose.
Well, why would they need to put on that evidence if it was clearly by virtue of your complaint in personam relief?
Well, again, let's take this one single line out of the order that it runs with the land. Absent of that language, it does not change the result whatsoever. It still gets rid of the lights. They did offer an alternate, which is to put basically the clamshell over the top of the light so they shine straight down onto the dock instead of the water, like you had suggested earlier. So there was alternate relief, but they stopped them from doing it. By adding in the run with the land option, I don't think it changed anything other than stopping this issue from reappearing before the court. If that language was not included in the order, there would be the nuisance would still be there. The relief that our clients sought would still have been provided for within the order. So it's a standalone clause.
Let's turn the telescope around. What if your clients move away and the people who move in think maybe they're, I don't know, like lights shining in the back or whatever, and now you've got a position where somebody is either indifferent or actually aggrieved by the trial court's decision. I understand you looking at it through the lens of wanting to safeguard your client's interests. That's your job. But when you have something that runs with the land, it runs with the land. I mean, it runs with the land 150, 200 years from now.
Yes, sir, and I understand that. And by recording this order, every future owner, both on the Brown and the Butler side, are going to be aware of this order, that you can't shine bright lights in from the dock into their home. You can use shielded lights that shine on the dock itself. Everyone will have notice ahead of time.
Right, and
prior.
the ability to decide whether or not they want to buy the house.
Absolutely.
Which
and
is
if they
exactly the notice that wasn't provided in the complaint. And I think that that's kind of where I'm coming from in that perspective, is that if it's so important for any future buyer to know what you can and can't do with the house, that's why we have Schedule Bs on title reports, right?
Yes, sir.
So you know that you're going to take to these particular exceptions to title. In the exact same situation, that notice has been deprived of the defendants in the underlying lawsuit. And I think that's where my struggle is, because you've got that situation that you clearly outlined going forward, that everybody knows now because of this recorded judgment that you're going to have this issue that runs with the land. Whereas perhaps this lawsuit would have been litigated differently, or even if it wasn't litigated differently, perhaps the defendant should have been on notice as to what they stood to lose. And I just ask for your general reaction to that.
General reaction is that the run with the land language is excess language. I agree that it was that request was not made within the pleadings. It was added in by the judge, and I think the judge specifically added that in on his own accord, because again, that language does not appear in the pleadings, but to satisfy the equitable need to resolve this issue completely. And I think that, and again, I can't speak for the judge, but in just reading in that, I think that is why it was included. I don't think that the view was this is going to change the rights of future owners. It does. It runs with the land. But I think it was more saying bright lights are not allowed. And I don't care if it's the Butlers that own the house or Butler's entity or the Butler's friends that buy the house in the future. We're not going to allow those lights. We've made our decision on this matter. Shielded lights facing down into the dock that provide security, great. We're good with that. But if you're going to shine bright lights into the water that are a rope light style, that's not going to be allowed. And I don't care if it's the Butlers who own it or anyone else. And I think that was why that extra language is included in the order. But again, remove that extra language and we're still in the same place we are. That those dock lights are improper. It's a nuisance. And the court found it, had reasonable reasons to base its decisions on. And as As the courts have found, the appellate courts, and again, it's cited in Williams versus River Bend of Cocoa Beach case. By this, you're not going to disturb a judge's ruling if it's based on competent substantial evidence, which we have. And again, you had spoken about the visit. Well, it's also in the testimony of the parties. It's also in the photographs of the complaint. There's other means. And if you look at the Research and Design, Inc. versus Helco, also cited in our case, the appellate level is not going to overturn a case unless every single basis of possible, and I'll read it. A final judgment entered after a bench trial must be affirmed where the appellant fails to demonstrate that all of the alternate bases relied upon by the trial court were unsupported by competent substantial evidence, because under these circumstances, an appellate court has no authority to set aside the decision of the trial court. Clearly, there was testimony, and I find it a bit disingenuous where in the briefs, they're saying that the testimony of our client should be disregarded as self-serving. But even today, before the court, the testimony of the opposing party should be taken as unquestioned fact and evidence. It's not the case. The evidence was before the court. The court weighed the evidence, weighed the veracity and the honesty of what they believed the witnesses were, and they made their decision based on facts that were very well supported in a number of different ways, pages of ways that they included within the court order. So again, it's just this single run with the land issue, that one statement that was included. But again, X that out as if the judge didn't ever put that in, and there would not be an appealable issue here. We would be back down to if there was any supportable means to support, and there were, the testimony, the pictures, the visit, to again, judge for the judge to
Counselor,
look for
can I ask you a
himself.
question about jurisdiction?
Yes.
Counsel for the appellant spoke of the lack of jurisdiction the trial court had, and she believed that it was subject matter jurisdiction that the court lacked to grant the relief that they did. What would you say?
I would disagree with that. This issue was before the court on an equitable basis, seeking both a nuisance and an injunction based on that nuisance, and this is all tied together. This is sufficient notice. Clearly, the court has jurisdiction to hear both nuisance issues and injunction issues, and that's what they did.
Did they have jurisdiction to grant relief over the land for all of time, which is what Judge Traver's point is? That's the 900-pound gorilla in the room. I think that they had jurisdiction and ability to do everything in that order clearly, without question, with the exception of the run with the land. That is the one issue I think that is subject to gray area discussions, and that's why we're here today. If we reverse because the court lacked jurisdiction, or if we reverse because there was a due process violation below and the court granted relief which was never requested or at issue, what should the remand instructions look like?
It should be very simple. Remove paragraph.
And I ask that because the trial court makes a finding in their order of damages, monetary damages, but then doesn't impose them and seems to grant an alternative form of relief. And that's why I wanted to get you to weigh in on that question.
Yeah, I would say that if it were going to be remanded based on the run with the land language, I think it should be remanded with specific instructions to remove run with the land language at one sole paragraph within the final judgment, because everything else is justified, was properly before the court. And again, I think gray area that even the run with the land issue was, because I think the court in equity has got the ability to craft a order that they believe to be inclusive to resolve this issue permanently. And that was the method that they chose. Was it the best method? Obviously not. We're here today on that issue, but all of the other matters, again, it doesn't change the outcome. There was plenty of notice. All other issues were properly before the court. It's just this one run with the land issue. So on a remand, that would be the only issue I believe that could be altered and changed. I would suggest that it would be, if that were how the court is inclined, that it's remanded with instructions specifically to remove the run with the land and to affirm otherwise, because again, there is sufficient justification for all of the findings of the court, with the exception of the run with the land.
Has the judgment been recorded?
That I do not know. I'm sorry. Nathan, do you know by chance? It has been.
Thank you.
So the amended judgment, if we did reverse on the first issue, the remand instructions might include recording?
I would think so, yes. I think that would make logical sense, and I think that would be a necessity, actually, because if there was a subsequent finding, it would be pertinent that it would be recorded as well. So, I've got a few minutes left. I just want to go through some wrap-up. We have to keep in mind that there is a presumption of correctness that trial courts are going to have. The trial court sits in the best seat to judge, again, the veracity and the honesty of the witnesses, to look at all of the facts as presented to it. They sat through the trial and the events leading up to it. There is very, very clear testimony, documents. There's a couple of witnesses. I find it interesting that there's two appraisal witnesses, but only one that actually went to the property of the Browns. So I don't know how you can appraise a property by not actually going to the property. Instead, the cited references to to the second appraiser hired by the defendants in this case was about, well, I would have put lights on the dock. That's nothing that he's a real estate appraiser, so that would be irrelevant. But there was no discussion. The court heard all this discussion, and heard the testimony and made its decision and made a very, very detailed court finding. And that's entitled to a presumption of correctness unless it's clearly wrong by law or oversees certain things. Any of those bases could have brought forth the result that it did. They put in a number of them. Any one of those could have gotten the result of the judgment that was brought forth by the court. So I think that relying on that presumption of correctness gets us through everything with the exception of that one run with the land. That's the issue. But again, that doesn't change anything with the case. This case was tried. It was brought forth by both sides. Everyone had a chance to object accordingly, whether they chose to or not, on certain issues, such as the visit. And ultimately, the judge made a determination based on those facts. It's not an abuse of discretion to make the decisions that he did. He justified it very, very well in the court order. The plaintiffs didn't ask for it to run with the land. That was language that was provided for by the judge. I think that it was gray area justified again, because I think the judge was looking at this as being something that's going to come back to him. And this, sitting in equity, he's got the power to make those choices, to draft a decision. And he actually references that in his court order. The court, sitting in equity, has the ability to abate nuisances that exist utilizing its equitable powers. And it cites to the Pompano Horse Course. But I think that is where the judge was looking, saying, I'm gonna put a permanent end to this. Change the lights or keep them off forever. And that's why I put the language, run with the land. But remove that language. The rest of the court order is very, very clear, very, very justified, and should stay in place regardless of ultimately how you rule on this matter. So I appreciate your time. Thank you very much.
Thank you.
I want to quickly return to the view and the issue of security. I would suggest to you that what we do not have here is a credibility determination, because what happened here is the butler said, we've had trespassers, this lights up the way for the trespassers so they can. When the judge made the finding, I need a flashlight, and it doesn't, the butlers were not able to cross-examine that. They weren't able to bring any type of rebuttal or other evidence to confront that or challenge that. They didn't know that was what that this fact existed out there or that this evidence was going to be used against them. So that's the problem here, because this isn't a nuisance if there's a reasonable use. And so when the judge made that finding, that's why this, in my opinion, is so important, is because the Butlers couldn't come in and ask the judge, well, I'm never good at on-the-spot questions, but what if they said, well, do you wear glasses? Do you walk with a cane? Why did he need a flashlight? We don't know that. And the Butlers weren't able to come in and cross-examine that, present some other type of rebuttal, conflicting evidence to that. That's why this is so important. And it goes to the very heart of why this was a reasonable use. So I want to just spend just a minute, because I only have 50 seconds left, on the harm. Not only do you need an interference, but you need a harm. And we don't have any evidence of harm here. There's no medical records, there's no lost work. And the appraisal, I touch on this in the brief, the appraisal, the lost value, I would suggest to you is not harm. That this is just a potential, and there's some case law, not out of Florida that deals with this, but out of Pennsylvania, I believe, that talks about how that is not a harm that supports a cognizable claim for nuisance. We don't have medical records that these individuals have any ill effects from the lights. There's no missed work. There's no bills paid. We don't have any harm. And it's a two-part. Not only do we have to have an interference, but you need to have a resulting harm, like we would in any tort action. And where there's a lack of evidence of harm here. So, unless you have any other questions. Thank you very much.
You both.